Section 44A of the Elections Act. A clear understanding ought to be made of the components of our electoral system, whether electronic or manual. So which begs an answer to the question, what constitutes the electoral system in Kenya? Now, Article 83 says, a citizen who qualifies for registration as a voter shall be registered at one registration center. Administration arrangements for the registration of the voter and the conduct of elections shall be designed to facilitate so that an eligible citizen can vote or stand for election. Section 4 of the Election Act provides that the IEBC shall compile and maintain a register of voters. And Section 5 of the Elections Act provides that the registration of voters and the revision of the register of voters under this Act shall be carried out at all times, and the registration officer or other authorized officer shall transmit the information relating to the registration of the voter to the Commission for inclusion in the Register of Voters. Now, Section 44 of the Elections Act provides that, subject to this section, there is established an integrated electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. These provisions are the basis of registration of voters by the Commission. Registration of voters in Kenya is conducted when the voter physically goes to the registration center. His details are manually inputted into an electronic system. His biometrics are physically taken as part of his identification mechanism. The regulation says that when he applies to be registered, to be registered as a voter, he goes and takes his ID to the registration officer, and then he has to fill a form, and then it is the officer who then inputs the details of the form into the electronic system, and then the voter is even given a slip, a physical slip, to say that he has registered. Then the officer then compiles the register of voters manually and takes it to the Commission. So although we say that registration is electronic, yet it is done manually by the registration officer to do it. And the voter must be physically present to do it. Also, during the elections, the voter has to go to the polling station himself with his ID, which he has to show, check his fingerprints, then he's identified, and there's an officer who then marks manually his name off the register. Then he is physically given a paper ballot. Then he has to go and physically mark the ballot, and he has to put the ballot inside the box. When the counting is finished, when the voting is finished, then everybody comes together, the agents and the officials. They physically take the boxes, they open them, they pour the ballots on the table, and they physically count them, and they physically fill in the Form 34A. So it is clear that the counting of votes, the declaration of votes is manual. But the transmission is electronic. So our electoral process is not purely electronic. It comprises both manual and electronic components. And when the electronic component fails, the manual component kicks in. In my opinion, this is a rather ugly, grouchy, reluctant mongrel of two distinct processes. It's largely a manual system. That's what we have. It is distinct from electoral processes in countries like India, Australia, or the United States, where everything is electronic. In India, you go, you punch in the machine, you punch in where the candidate's name is. Everything is done with a machine. Similarly, in the America. But in Kenya, this mongrel is something that needs to be looked at. This mongrel is what is causing us this problem. And it is not upon this court to look at this mongrel. There are those in the legislature who must look at this mongrel that they created and bring clarity so that what we do is have a thoroughbred and not a mongrel of a system. However, going back to interpretation of Section 44A in terms of the law, although I don't know if I need to get into this, you see, the High Court, I think it's important that I say this. The High Court talked about a complementary system in 44A, which complements the system in 44. And they went to look at the word notwithstanding. Looking at 44A, what is the meaning of notwithstanding? And their conclusion was, accordingly, our determination on what constitutes the components of a complementary mechanism to be established under 44A of the Act is that the mechanism ought to be separate, but it is to improve what is already in 44. Article 39(1)(c) mandates that for the purposes of a presidential election, the Commission shall electronically transmit in the prescribed form, the tabulated results of an election of the President from a polling station to the constituency tallying center. Technology, however, per Section 44, is used subject to the provisions of the entire section, meaning that there are prerequisites to be met before technology can be employed. Parliament was keen to introduce conditions preceding the use of technology in elections, and those conditions are built in the provision as follows. 1, a policy for progressive use of technology in the electoral process. That's in Section 44(2), progressive use of technology. 2, the technology is supposed to be simple. 3, in an open and transparent manner, the technology must be procured at least 120 days before. 4, the technology must be deployed at least 60 days before an election. 5, there are regulations which must be done in consultation with stakeholders. 6, the technology is restricted to voter registration, identification, and transmission. And then there is a committee that's supposed to overlook all this. It is imperative at this juncture to highlight that the use of technology is progressive. Kenya's electoral system is a vivid recollection of progressive improvement. Imagine from Mulolongo, that made no use of paper ballots, to the introduction of paper ballots, the development of statutory transmission forms, and several layers of verification, to the maiden introduction of technology during 2013 elections, whose partial failure inspired the introduction of KIMS, which returned proper voter registration, identification, and sufficient voter transmission with a verifiable paper trail. I want to reiterate the finding of this of the Raila 2013, where we said, from case law and from Kenya's electoral history, it is apparent that electronic technology has not provided perfect solutions. Such technology has been inherently undependable, and its adoption and application only incremental over time. It is not surprising that the applicable law has entrusted a discretion to IEBC on the application of such technology as may be found appropriate. Since such technology has not achieved a level of reliability, it cannot as yet be considered a permanent or irreversible foundation for the conduct of the electoral process. This negates the petitioner's contention that in the instance case, injustice or illegality in the conduct of election would result if IEBC did not consistently employ electronic technology. It follows that the petitioner's case, insofar as it attributes nullity to the presidential election on grounds of failed technological devices, is not sustainable. The petitioners and other interested parties sought guidance from the courts on a significant aspect of these prerequisites, which were all settled in time for the elections. In light of the provisions relating to the use of technology in elections and the transmission of results in a presidential election, Parliament introduced a non-obstante clause. A non-obstante clause in the terms of Section 44A, mandating the Commission to put in place a complementary mechanism for identification of voters and transmission of election results. According to Black's Law Dictionary, a non-obstante clause is one which gives effect, despite any laws to the contrary, and which precludes interpretation contrary to the stated object or purpose. The Constitution and the entire Electoral Code enliven this mechanism. The manual identification of voters, the manual transmission of results in the prescribed instruments of transmission, verifiable by various agents, including an election court, using election material and defined under the Elections Act. The essence of this section was to save the sovereign will of the people from the unpredictable nature of technology and to introduce a layer of verifiability to the electoral process. Parliament was clear by terms of Section 44A that the complementary mechanism, which exists as the manual system of results transmission in the prescribed instruments of declaration and whose finality is only questionable before an election court, was sufficient to deliver a presidential election, as happened in the areas where there was no 3G or 4G network coverage. I have already laid out the provisions of Article 86D of the Constitution, which provides for the security of electoral materials. Section 2 of the Elections Act defines election material to mean ballot boxes, ballot papers, counterfoils, envelopes, packet statements, and other documents used in connection with voting, and includes information technology equipment used for voting. The voting compartments, instruments, seals, and other materials and things required for the purpose of conducting an election. These items exist. Their non-utility, compromise, interference, or unavailability for the purposes of inspections was not challenged. Notwithstanding the shortcomings of the technology in terms of Article 44A, these materials stood as a testament of these election acts exercised by millions of Kenyans, an exercise which the majority has termed irrelevant, unfortunately. The Constitution of Kenya is one drawn for efficiency. It communicates purpose of timelines. In Mary Wamboi, this court held that the electoral history of Kenya is replete with cases of delay in finalizing matters, therefore denying voters the opportunity to have their chosen representatives in the organs of governance. It is clear that the sovereign power belongs to the people and is exercised directly or through their democratically elected representatives in state organs, which Parliament and the legislative assemblies and county governments. The voters' rights in this regard are quite clear. Article 138 is replete with these directives of time. 138.5, 138.9, 138.10. The Constitution gives the chairperson of the Commission a maximum period of 7 days within which to declare a result of the election and to deliver a written notification. This imperative allows enough time for the Commission to tally, verify, and count the results from the polling station and to declare the result. The complementary mechanism referred to in Section 44A of the Elections Act is a function of verification. I am persuaded by the determination of the German case in judgment of the Second Senate that the public nature of elections requires all essential steps in the elections to be subject to examinability unless other interests justify an exception. This examination must be possible by the voter without special expert knowledge. Therefore, the voter in Kenya understands the function of the ballot and the critical importance of entries in statutory forms 34A, 34B, and 34C. The election results are displayed in the relevant forms after the close of polling for all to see and scrutinize. Any mechanism that purports to complicate this simplicity is at variance with the Constitution. The technology reinforces the efficient, fast translation of the will of the people into an ascertainable return. It, however, does not supplant the critical primary instrument, which is Form 34A, generated at the primary locus of the election and challengeable only in a court of law. In my view, the claim of a consistent 11% variance between the results for the third respondent and the first petitioner, in my view, were not proved. And having determined that the failure of technology could not supplant the will of the people, recorded in verifiable ballots and other election materials, and results declared in A, available, ascertainable, unchallenged, proper statutory instruments of declaration, it is, in my opinion, that the petitioner's case to exclude results from 11,000 polling stations, which were out of 3G and 4G network, would be an affront to the Constitution and the right to franchise. I now have a section which is to do with the rejected votes. I'm not at variance with the findings of the majority on this. I have different reasoning as to why the rejected votes should not be counted. I have different definitions, but my conclusion is not at variance with the majority, and therefore I will skip that part and leave it for you to read when you get the document. Let me move to burden of proof. It is straight law that whoever alleges must prove. And the Evidence Act stipulates in the following terms: whoever desires any court to give a judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove those facts exist. When a person is bound to prove evidence of any fact, it is said that the burden of proof lies on that person. The court has had the opportunity to pronounce itself on the burden of proof in a presidential election, which we did in Raila 2013, where we said there is apparently a common thread in the foregoing comparative jurisprudence on burden of proof in election cases. Its essence is that an electoral cause is established much the same way as a civil cause. The legal burden rests upon the petitioner, but depending on the effectiveness with which he discharges this, the evidential burden keeps shifting. Ultimately, of course, it falls to the court to determine whether a firm and an unanswered case has been made. The court further held, quoted with affirmation by this court in Munya 2, where at paragraph 178 we said, one of the grounds for impugning the judgment of the Court of Appeal was that the court shifted the burden of proof from the petitioner to the second and third respondents, contrary to the holding by this court in Raila Odinga and another. Regarding this burden of proof, this court held that a petitioner should be under obligation to discharge the initial burden of proof before the respondents are invited to bear the evidential burden. The threshold of proof should be, in principle, be above the balance of probabilities, though not as high as beyond reasonable doubt. Where a party alleges non-conformity with electoral law, the petitioner must not only prove that there has been non-compliance with the law, but that such failure of compliance did affect the validity of the elections. It is on that basis that the respondents bear the burden of proving the contrary. We affirm that this statement represents the legal position regarding the question of burden of proof in election petitions. This court elaborated on the distinction between the legal burden and the evidentiary burden, noting that the legal burden is the initial burden on the petitioner to prove the facts pleaded on the petition, and once the petitioner discharges the legal burden to the standard required, then the burden shifts to the respondent to disprove the claims, that being the evidentiary burden. The court held as follows. The allegation that the total number of votes cast exceeds the number of registered voters is such a serious one that the election court will not treat it lightly. If proved, such an occurrence would call into question the integrity of the electoral process. The person who makes such an allegation must lead evidence to prove the fact. She or he bears the initial legal burden of proof, which she or he must discharge. The legal burden in this regard is not just a notion behind which any party can hide. It is a vital requirement of the law. On the other hand, the evidential burden is a shifting one, and it is a requisite response to an already discharged initial burden. The evidential burden is the obligation to show, if called upon to do so, that there is sufficient evidence to raise an issue as to the existence or non-existence of a fact in issue. In an electoral cause, the legal burden rests on the petitioner. The petitioner must discharge the initial burden for the first respondent to be under evidentiary burden. Again, I have quoted Munya and a number of Indian cases which have also supported the case regarding the burden of proof. In an Indian court, in the Indian Supreme Court, they emphasize the grave need for the petitioner to discharge the burden of proof before an election is upset. They said, quote, if the petitioner is unable to adduce evidence in a case such as the present, the only inescapable conclusion to which the tribunal can come is that the burden is not discharged and that the election must stand. Such a result may operate harshly upon the petitioner seeking to set aside the election, but neither the tribunal or this court is concerned with the inconvenience resulting from the operation of the law. How this state of things can be remedied is a matter entirely for the legislature to consider. The English Act, which we have referred to, presents no such conundrum and lays down a perfectly sensible criterion upon which the tribunal can proceed to declare its opinion. It directs the tribunal not to set aside the election if it is of the opinion that the irregularity has not materially affected the result. Thus, the petitioner in this case must discharge the burden of proof in order to succeed in their pursuit to invalidate the declared result. The petitioner must prove the irregularity was committed, but in my opinion, that the irregularity materially affected the election result. Section 83 of the Evidence Act, Section 83 of the Elections Act, specifically requires that no election shall be declared by void of non-compliance with written law if it appears that the election was conducted in accordance with the Constitution and with written law, or that the non-compliance did not affect the result of the election. The implication of this provision are addressed in detail later on in this judgment. In the standard of proof, in election offences, the standard of proof again was held by this court in Ryla 2013 to be higher than the balance of probabilities, but below reasonable doubt, and I have quoted what we said in that matter. More specifically, where a claim of electoral malpractice is made, the standard of proof is one above balance of probabilities, but below beyond reasonable doubt. Where a claim of commission of an election offense is made, then the standard of proof is similar to a criminal matter, and it is beyond reasonable doubt. Where the claim relates to data-specific electoral requirements, the standard of proof is also beyond reasonable doubt. I have also quoted Wetangula, where we spoke to the standard in terms of election offenses. Applying the principles espoused above, it is clear that the onus is upon the petitioners to prove beyond a reasonable doubt that the third respondent committed the said electoral offences with detailed specificity by way of cogent evidence and bear allegations of commission of such offences, as has been done, would fall short of that standard. petitioners had alleged that there was an election offences committed by cabinet secretaries and other public officers misusing state resources in favour of specific candidates. Using the test of beyond reasonable doubt, I find that the petitioner failed on this issue. I think the petitioner must first show that the offences were committed, and then secondly, that they were acting under instructions of the third respondent. So they have to show a nexus between the person who is alleged to have committed the offence and the returned candidate. And they must show the full particulars of that election. This was the finding, which I agree with, and jurisprudence of the Supreme Court in India when they were making the determination in the case of Jagdev Smigli versus Pratap Singh Duala. I have laid out a number of Indian cases. They obviously have a lot of challenges with election offences, and having laid out those standards, I have said that I am persuaded that the petitioners in this case have failed to prove full particulars of the electoral offences that they allege were committed by the third respondent. And I would therefore have, at this instance, struck out all allegations of illegality from their petition for want of particulars as required by the law. There is also the alleged electoral offences regarding bribery, intimidation, and undue influence, and I think that that was properly addressed by the Chief Justice when he spoke to the provisions of the Leadership and Integrity chapter of the Constitution, and also Section 23 of the Leadership and Integrity Act, which provides that an appointed state officer other than a cabinet secretary or a member of the county executive committee shall not, in their performance of duties, engage in politics. However, I wanted to add something on that issue. For me, in my opinion, the law is clear that the cabinet secretaries are exempt from the prohibition that public officers should not engage in the activities of a political nature, and for good reason. It is to be observed that cabinet secretaries and county executive members do serve at the pleasure of either the president or governor. They are political appointees with the express purpose of delivering the